Okay, thank you very much everybody for coming. We're going to start now. Hopefully we'll finish on time. Thank you for coming this evening. Welcome to Downton Street Chambers. The whole point of this evening's seminar, hopefully, is to enthuse you in relation to the benefits to your clients who are mixed up in criminal proceedings or even simply in the investigation stage of civil litigation. Now, our speakers this evening are all members of the Chamber's Actions Against the Police and Public Authorities team. You probably know that Chambers is listed in the directories as the go-to set for police claimant work, so we have a lot of expertise in the area. There's more information in your packs about the individual speakers and indeed about the team. We're going to hear later on from Rupert Bowers, Queen's Counsel, who specialises in using judicial review to challenge the lawfulness of search warrants and related issues. But we're first of all going to kick off with Paddy O'Connor, who sits at the end, Paddy O'Connor, Queen's Counsel, who hopefully is going to give us an overview of the parameters of civil litigation in this context, in circumstances when your clients have been acquitted after a trial, or perhaps their convictions have been quashed in the Court of Appeal. And then following Paddy will be Nick Brown, who's going to develop the two main causes of action, false imprisonment and malicious prosecution. The plan is that each speaker will take about 15 minutes to address you. There should be time for some questions, and then there'll be drinks and some snacks, and I hope you'll get to those by about 7:30. Okay, Paddy, over to you.
Thank you, Becky. And the object of inviting you here this evening, as Becky has summarised, is to explain to you the broad significance, quite how broad it is, for your clients in criminal litigation of civil litigation, and to enthuse you because it's a very exciting field to get involved in, and you may leave this evening hopefully at best with thoughts of, if you don't have a police action department, maybe you can train up some of your existing solicitors or recruit, or at the very least, even if you're not going to do it yourselves, sift your cases. At the end, whatever the result, actually, it's wider than even Becky indicated. This is not confined to your acquitted clients, your convicted clients. You may have a guilty client who's been beaten up. To sift your cases, to see if there are any potential civil litigation implications at the end of the criminal litigation, and if you're not going to do it yourself, pass it on to others for more detailed assessment. Now, I'm going to break the habit of lifetime and actually follow at least the first 2 pages of this PowerPoint, and so I'm going to take you to, here we are, why civil litigation? Well, as you probably know, as a result of a civil claim, you get a finding, depending on which course of action your claim is based upon, and that finding, if it's with a judge alone, will be reasoned, and that will provide a very significant basis for future implications beyond even the damages action itself, and vindication for your client, who will be told one way or another whether he or she has been believed and has been telling the truth, and whether very often the police officers on the other side have been lying. So you get clear findings from a judge alone, which applies to very many civil actions, but even if you have a jury deciding the case, liability in the case and damages, these days the jury are asked questions tailored to the nature of the case. So, to keep it simple, an obvious example, the jury will be asked not just, if they find for the claimant in terms of battery or assault, but they'll be asked, did PCX and PCY use unreasonable force on the claimant in restraining him? And the jury will say yes or no. And you get a clear finding. And then you can also learn quite a lot, even if it's a jury, from their award or not of aggravated and exemplary damages. If they think it's a really, really bad case, they will of course give both. So clear findings of police wrongdoing, accountability and vindication, and you won't need us to explain to you how ineffective the complaints and discipline system is. The client gets damages, but can I say that actually clients who have genuinely been very badly treated find the vindication element at least as important as the damages. They're not all venal. They walk out of court with their heads held high, and that is worth more than £5,000 or £10,000 to very many of them. But they also get the damages, which is quite handy. There are now very many flexible outcomes for civil litigation before trial, and they can involve great satisfaction for the client. Apologies, negotiation, mediation, coming together. Some police officers, in my experience, actually refuse to meet the claimant because they are so set in their ways. But others may act more reasonably, and the client will get a satisfaction from that. Can I just add something to this page? It's really rather gratifying to see and sense the discomfiture of police officers when they have to attend a civil court for trial. It's not their local magistrates' court or Crown Court. They're not, at ease there, knowing the criminal procedure rules and pace, so it's nothing to do with that. They feel out of place, out of control. They don't know quite where the case may be going. They may sense that if there is a stinging victory for the claimant, discipline proceedings may follow. And that in itself is, dare I suggest, a good thing. Now, some warning notes, though. We can't go into this gung-ho, because proceedings will very often not be started, for damages anyway, before the conclusion of criminal litigation. And even the simplest action takes a fair amount of time to come for trial. What with the pleadings, disclosure, exchange of witness statements, it all takes time, and it is much more complicated than criminal litigation. Some clients don't want to go there and can't take it. And the next heading is, of course, the experience they have in the witness box. Police lawyers, that is lawyers acting for police forces now, are much more aggressive than they used to be. They can be quite sadistic, actually, and it's difficult to restrain them within proper boundaries. And it's a duty really to warn clients how uncomfortable it may be for them. So it's not for everyone. And then we get procedural complexity, which I'm certainly not going to go into. If you require detailed training from us, that's the kind of thing we'll go into and help you with. That cost budgeting, setting your costs in advance, keeping to it, applying in good time to expand it, is absolutely critical. And if you handle that wrongly, you can win the case, and yet the lawyers may get a fraction of the remuneration they're entitled to. So those are some warning notes. Now, having done that, I'm going to tell you two stories. One is a saga, and it is, in my experience, the ultimate explanation of how wide the implications of civil litigation can be. And Mr. Treadaway came to us. He was a charming old robber, glint in his eye, lovely man, lots of previous convictions. And he claimed he'd been suffocated to unconsciousness with plastic bags by officers of the West Midlands Serious Crime Squad to force him to sign a confession. Torture. And for those of you who don't remember or are too young, the West Midlands Serious Crime Squad was so bad that it was disbanded by its own chief constable as being out of control. So on the face of it, he may well have been telling the truth, but there were some problems. He had been convicted on the basis of this confession, and he was still serving his sentence. He had started an action for battery, but it had been struck out as an abusive process. as you may well know, for trying to relitigate an issue which he'd lost in the criminal trial. He was out of time for appealing, and there was no legal aid. So it was a bit of a mountain to climb before we could get anywhere in this case. So Raju Bhatt and I, who maybe you may have heard, solicitor, we went to the Legal Aid Committee. We persuaded them there was a decent chance of appealing this because there was another basis for the conviction, an accomplice. We go along, we get legal aid extended to pursue the appeal against the Strike Act. We go to the Court of Appeal, we get permission to appeal. We go on the full appeal and we win. So the way is straight ahead for a trial of this action on its merits. And basically this is Mr. Treadaway, convicted armed robber, still saying he was innocent, but with his conviction extant, saying this is what happened to me. A tiny bit of expert evidence about petechiae on his skin, which was ambiguous but would be consistent with him having had some trauma to the neck, some restriction to his neck. And 6 detectives from West Midlands Serious Crime Squad, one of them a superintendent. And because it's battery, no entitlement to a jury, judge alone. We come in front of Mr. Justice McKenna, quite a right-wing judge, but as you probably know, those judges can be very good if they take a dislike to officers and their dishonesty. Mr. Treadaway is believed, and we win. And he is awarded £50,000 damages. It's in the textbook. And the argument about exemplary damages was successful in the sense that you don't give less damages to somebody who is a bit of a villain, because police officers like this who are so minded are not going to try to suffocate the Archbishop of Canterbury. It's precisely this kind of client who needs protection by way of an award of exemplary damages for the future, and that's why this judge awarded such a high award. So, right, I perhaps wouldn't even tell you the story if it stopped there, but it didn't. Because, of course, somewhat hypocritically, having avoided the Strike Act and said, oh, this isn't a collateral attack on the conviction at all, we thought, well, now we've won this. And we got a 50-page judgment from the High Court judge explaining why he'd believed our client, disbelieved the officers. We thought, well, what about this criminal conviction? So we go along to the Court of Appeal, and for you criminal lawyers, as you all are, a technical point arising out of this, which was of some interest, is what was the status of the High Court judge's judgment. And it was admitted under Section 23 of the Criminal Appeal Act as fresh evidence. It's not easy, that argument, and I've had to re-argue it since in another context. But the court accepted it, and the opponent was Goldring, who went on to the higher stratospheres of the judiciary. So we won using that judgment. So his conviction is quashed. It didn't stop there. What about these officers? They're still serving. They're still tempted to suffocate people with plastic bags in the right case or wrong case. So we sent the papers along to the CPS and said, here is your reasonable prospect of getting a conviction of these officers for torture, criminal offence. And do we need to even discuss the public interest? So please prosecute. So inevitably, under that DPP, who's nameless, wasn't Keir Starmer, we got a negative answer. So we judicially reviewed the decision, and it doesn't happen very often. 3 times in my experience, we succeeded, and the CPS was in such a state they couldn't even actually explain who'd made the decision. So we got a decision saying that the CPS had to re-examine this decision, and basically the message was out, they're going to have to prosecute these police officers for torture, which is pretty sensational. Here my story grinds to a halt, with actually a rather tragic and banal ending, because the charming Mr. Treadaway was enjoying his freedom and enjoying his damages in Amsterdam, which was a mistake. He fell into the canal and drowned. And that is the end of that story. otherwise there would have been a very sensational, this saga would have gone on to even more extraordinary twists and turns. Now that was quite a saga. Can I just tell you a very brief and sort of fun story? I've probably got a couple of minutes left.
3 or 4 minutes.
3 or 4 minutes? Brilliant. Fun case. Sledge Robinson. Wonderful street-level drug dealer in the All Saints Road, all linked with the Mangrove, and Frank Richlow and everyone. He's an absolutely great guy. And he was suing the police already for malicious prosecution, unclouting him, etc., etc., etc. And he came along to us saying, look, I've been arrested again. And what's more, the officers said, oh, you're taking us to the civil courts, aren't you, etc. So we thought, well, hang on, this is contempt of court, an harassment of a litigant before Her Majesty's courts. So it was Christmas Eve, and we went along to the High Court to get an injunction against Notting Hill police officers from harassing him. And the police sent along a pretty inexperienced sort of rubbish lawyer. And believe it or not, we actually had an agreement. It's something out of a Carry On film, whereby instead of there being an injunction, they undertook to read out at the roll call of every shift of every uniformed police officer before they went out on patrol, you will not arrest Sledge Robinson. He almost had immunity from prosecution, no matter what he did. Anyway, there's a slightly banal ending to that, but it didn't quite work out because a sensible lawyer turned up, sort of wondered what was going on. But look, it's exciting. You can be creative. You can do stuff instead of just passively reacting, to the latest notice of additional evidence, etc., etc. I'm finally going to turn it on its head. What about you being approached by victims wanting a private prosecution, your criminal lawyers? It's not that often. Of course, it was tried unsuccessfully in Stephen Lawrence. Now, there are civil litigation implications to this. 2 cases in my own career, in both of which the CPS had failed to prosecute alleged murderers. One was Halford and Brooks in Derbyshire, a schoolgirl. One was Francisco and Diedrich, a poor woman who was stalked by an ex-boyfriend in St John's Wood and killed. In each case, we brought civil litigation to prove that the named person was a murderer, and he has yet been untried and unconvicted. In each case, we won. In each case, after that successful civil litigation, the evidence was re-examined and prosecutions were brought. And in each case, there was a conviction. And those 2 very dangerous, predatory murderers are behind bars because justice was attained for, if you like, criminal clients, but at the wrong end of the criminal justice system, victims not being protected, their interests not being protected by state prosecutors. And with civil procedure, which was pretty akin to a private prosecution, it's what happened in O.J. Simpson, you may remember. But it happened here first, actually. And hopefully that gives you the broadest possible horizon to look at this area of work, and hopefully enthuses you as well. Thank you.
Thank you very much, Paddy. And before we move on to Nick's presentation, I should just point out that in the handout there's some far less interesting, in fact mundane information, which is nonetheless an overview of the nuts and bolts of civil litigation in this area. So, moving to Nick, please.
Fuck off! Fuck off! That's what he said. That's why you hit him. That may be, probably is, bread and butter work, bread and butter cross-examination of a police officer in the sort of work that you do, or some of your colleagues do on a day-to-day basis. Doesn't often happen to us as civil practitioners, but we do enjoy it. But I'm not simply gratuitously taking this opportunity to swear at you. There is a good reason for it. The first point is this: evidence like that is at the absolute heart of your typical civil action against the police. It's the sort of evidence that you should feel completely at home with. And it's the sort of work that, like us, you should enjoy. The second point is this: those few words actually encapsulate, in a nutshell, what my gobby 16-year-old client's civil claim was all about. Because if my client was believed, he's got 3 causes of action, hasn't he? First one, an assault. Police officer hit him. But what's happened, what so typically happens in these sorts of incidents, is the police officer has added insult to injury. He's not only hit the lad, he then, to cover his back, has arrested him on a cooked up charge of assaulting him, the police officer, and then prosecuted him. So, the two claims I'm meant to be talking about: false imprisonment and malicious prosecution. At its heart, you can see the claim for false imprisonment. It's there. The police officer hit him, my client, not the other way around. So, the police officer, quite clearly, as a matter of fact, if the client evidence is accepted and preferred to the police officers, clearly had objectively no reasonable grounds to suspect that my client had hit him. You have a successful claim in false imprisonment. Also, he quite clearly, if the officer hit him, and it wasn't the other way around, the officer clearly did not genuinely ever suspect, did he, that he had been assaulted by my client. He knew what had happened. He'd been there. He'd hit him. He'd known that he wasn't hit. Again, that's the basic and absolute heart of the claim for false imprisonment arising out of the initial arrest. Third potential claim, malicious prosecution. That comes from the charging my client with assaulting a police officer and then carrying on with the prosecution. 2 main elements of that claim: no reasonable and probable cause to believe that my client had hit this police officer. Well, clearly not. The police officer hit him, not the other way around. Final element, the final key element, malice. The police officer had no honest belief in his evidence that he had been hit by my client. He knew what had happened. He was covering up his own wrongdoing. That's what these claims are about, at their heart. And that's a typical case. That's what you'll see regularly. An incident in a street, an arrest at a demonstration, a swearing match. It's when it's your client's word against the police officers. It's when someone's lying about the absolute basics of the story here. So what are you looking for when these cases come across your desk? What's going to help you to identify what's going to be a civil action? Well, as already been said, quite clearly your client has to have been acquitted or never prosecuted in the first place, or the charges need to have been dropped. That's common sense. It's actually a bar to any claim for malicious prosecution, and it's never particularly attractive to argue that your client should never have been arrested in the first place if he's ultimately been convicted of the offence for which he was arrested. Second point. Do you think you can prove that one or more police officers involved in this case were dishonest? So you're looking at a case where your client's acquittal essentially relied on the fact that the judge or the magistrate's court or the jury must have rejected a police officer's evidence. It's the only way in which it makes sense. And that's not always sufficient, because obviously the dynamics of a civil case are very different. burden and standard of proof. It's your client is bringing a claim. It's not a case of just them getting the benefit of the doubt. What you're looking at here is you're looking for a sufficiently attractive case or an attractive individual often. That's often very important as well. When the judge or the jury, as the case may be, will want to hand over taxpayers' money that you paid over in your taxes or your rates or whatever it is to the local authority. Well, they'll want to hand over that money to that individual. That's the dynamic that you're looking for. So what are the key things to look out for in that context? Firstly, does your client's version of events make sense? So if we go off to the fuck off example, pretty plausible. If you've got, you look at your client, he's a nice 60-year-old gobby youth, he's been picked up for the third time that night, he accepts he's been provoked, he accepts he was a bit of an idiot, but he was not a complete idiot. I mean, he's telling you he's 5 foot nothing, he's 10 stone, he's not lost his marbles completely. Why on earth would he suddenly set upon these 3 20-stone police officers? Doesn't make sense. So you're looking for the story which is just inherently plausible. Secondly, you're looking for some objective evidence that one or more of the police officers were dishonest. CCTV is often enormously helpful. There was a very happy period when the police started video recording demonstrations, and that became what was accidentally caught on their cameras, became a very fruitful source of a whole battery of civil actions against the police. Now we've got, everybody carries phones about. People take footage of what's happening in these sorts of incidents. Absolute goldmine to you, both in your criminal practices and in civil actions. Sometimes what the police describe is simply physically impossible. The case once, police described my client being pinned down on the stairs, a typical terraced house, about 8 foot from the front door by 3 large, bulky police officers. And the claim in the suit against him was that he had somehow managed to work his arm round these 3 police officers, reach forward, stretching about 8, 9, 10 feet to the front door, and then slammed it shut on the foot of the 4th police officer. We had a view with the jury. Just doesn't make sense. You've got them bound to rights. Another good thing to look out for, the outraged member of the public who happened to be a bystander to the incident that took place. I'll give you 2 examples, one good, one bad. Good example, the lighthouse keeper in his 60s with his wife on dry land, effectively for the first time for 6 months, outraged by what they saw in the back of the police car. Went straight to the police station to report what they'd seen happening to my client in the back of that car. Even more outraged by how they were treated when they got to the police station by the inspector. Still outraged 3 years later when they walk into court. Fantastic witnesses.
Sorry.
Less good example. Someone named your client, someone who's on the run from the police at the time when he gives evidence, and who is nicked the moment he steps out of the witness box having concluded his evidence in your case. Not helpful. Other good objective evidence, medical evidence. Again, I'll just give you one example of a case where it all actually unravelled at the criminal trial, and the civil action settled very quickly afterwards. Simple case arising from a demonstration of, it was a prosecution for the demonstrator assaulting a police officer. At the trial, defence counsel gets this police officer to go through his evidence of the punch in enormous detail. And this police officer describes how My client lifted up his arm, his right arm, right in the air, and brought it down with the most enormous power into his chest, so that 6 months later, this officer could still feel the weight of the punch. It was 24 hours before he could breathe properly again. It was fantastic, just all out there. Claimant comes in to give his evidence, suffered a brachial plexus injury at birth. Can't lift his arm beyond about 6 inches from his side. Second witness, consultant, confirms he can't lift his arm more than 6 inches from his side because he suffered a brachial plexus injury. And that's why we're doing this talk, because it was the criminal solicitors who'd done all the hard work. They had teed up a really easy claim for false imprisonment that was worth a few £1,000s for that initial arrest and the time he spent in the police station, and that was worth quite a few more £1,000 for the malicious prosecution, because he was charged, because he spent 6 months on bail and then had to undergo a magistrate's court trial. That's what you're looking for. Okay, so what we're looking for ultimately is examples of abuse of power. That's what these cases are all about. 16-year-old who told the police officer to fuck off. No circumstances. It was a police officer who was ultimately the wrongdoer, who lost his temper, who then assaulted my client and then tried to cover up. He's the wrongdoer. Real abuse of power happens on the streets on a daily basis. Think of the brachial plexus injury. He's made it all up. Police officer's just made it all up, hasn't he? That's what you're looking for. Now, these are the simple cases, and I've concentrated on the simple cases because, for obvious reasons, the more complicated the cases are, the more difficult it will be. Now, so as a matter of common sense, if you have a VAT fraud and the equivalent of 100 A4 ring binder files of evidence, it's going to be much more difficult to show that the arresting officer did not honestly suspect your client might be guilty and did not have objective grounds to suspect that when he arrested him. It clearly will be, but it still may be possible on the right cases. The point I'm making is you've got to be practical. There are obvious good practical reasons why there is a low threshold for which the police have to cross in order to justify an arrest, because otherwise there would be countless civil claims. And the police, as they will say, or their lawyers will say, spend far too much time or more time defending themselves doing what they were actually meant to be doing, i.e. arresting criminals. Different context. Murder charge. Perhaps 100 witnesses after months and months of investigation, some forensic evidence. Again, how easy will it be to show that there was insufficient evidence to even charge your client, even if the police have actually gilded the lily and done something dodgy at the end. Okay? The point is, as Paddy's highlighted with the Treadway case, it is still possible even with the most complicated cases. So you think Birmingham 6, you think Guildford 4, you think Cardiff 3, you think the dear old West Midlands Serious Crime Squad. And I mean, I know Paddy said it doesn't happen to the Archbishop of Canterbury, but it can sometimes, if you're unfortunate, and particularly the West Midlands Serious Crime Squad, happen to some very upstanding members of society. So George Reid, who actually ran the Birmingham 6 investigation, poor old George's career came to an end as a result of an incident on Christmas morning 1975, when George and the boys turned up on this guy's doorstep at about 3 o'clock in the morning, battered down the front door, went upstairs. There was this bloke in bed, naked, with his partner. They dragged him out of bed, they beat him up a bit in the bedroom, they chucked him down the stairs, they did him over a bit more in the sitting room, and then got round to asking him his name. And oh dear, the bloke they wanted had moved out 6 months before. He rang Christian Aid for the area. Okay. Now, again, what we're trying to do is give you a flavour of what these cases are about. We really enjoy the work. We've got a handout, I'm afraid I haven't referred to it at all. It's full of lots of good technical stuff about the burden and standard of proof, the elements of your cause of action, and we hope it's helpful for you when you go away. But the overall point is really this work is essentially common sense. Follow your instinct. If at the end of a case and someone's got off, you think, you lucky, lucky bastard, it's unlikely you've got a good action. If at the end of a case you think, that was an absolute outrage, you should never even have been arrested, that's when you start thinking it through, investigating, have I got a civil claim here? And if you're unsure, come to us. Thank you very much.
Nick, and as he said, if you would like a summary of the elements of the causes of action, information on damages and so on, you have it in your pack set out in hopefully clear bullet points. Rupert.
Just click through what we've missed. Little way to go, yeah.
Broad brush, that's
All right. Claims relating to search and seizure fall largely into two categories. What you've been hearing about is the fallout, if you like, from criminal process. So you go through the criminal process, you're looking for the sort of things that both Nick and Paddy have been telling you about, and if there's something good in there worth challenging or bringing a claim for, you can then litigate it after the event. Well, that's the second part of challenging the process, or challenging claims, or bringing claims related to search and seizure. But the first is really what I do, and that's challenging the process in relation to search and seizure. And the process will be usually obtaining search warrants, executing those warrants, but also other forms of search, such as Section 18 or Section 32, PACE powers, and seizures under Section 19. And of course, rather when you bring challenges to those powers by way of judicial review, you're not doing it after the event. This is engaging, very much engaging, not even with the prosecution process, but with the investigation itself. In an ideal world, you will challenge a search warrant or seek injunctive relief first off, within the first week or so of that warrant being executed. And whilst that may not be the beginning of an investigation into your client, it will be certainly the first time that investigation becomes known to him. In other words, becomes overt. So in challenging the process, it's important because you are directly able to engage with the course of an investigation before any charges are even contemplated. So, why challenge? Two aspects to it, and they're the bold headings. There's the client's perspective and the lawyer's perspective, particularly as solicitors. Important to you, less so to us as counsel, but important to you. Why? Well, what's the starting point usually? The starting point to most cases, certainly the fraud type cases or money laundering type cases, the bigger cases, will be you get a call or a knock on the door of your offices from a rather distressed client who's been subject that day, the day before, to a dawn raid on his, probably his house, probably his business premises also. He's had his computers, his phones, his documentation, various personal effects from his house probably taken away. He's had the violation of his or her house and the general upset that causes. It's going to make it very difficult for him to run his business. If it's a business that's been targeted, almost impossible. Indeed, that's often the aim, is it not? As we all know of some of these police tactics. He may also have been restrained at the same time, because we know, of course, that they go hand in hand. So, in the course of a very short space of time, your client or prospective client, as he may be at that point, can't run a business. He's had his personal items taken away, and his access to funds, which may hamper his initial ability to bring any challenge at all, has been restricted by a restraint order. That's a very, very common way that these cases start, and it'll be familiar to you all, I'm sure. He's going to be distraught about it, and he's going to want to know, in fairly short order, what you can do to alleviate the problems that he's now been caused. And so what he wants, or what he wants to hear from you, will depend on what motivates him, and it varies. And these are the subheadings under the client's perspective. So looking at why bring a challenge from the client's perspective, well, one, of course, will be that he wants his material returned. Not unreasonable, you might think, if computers have been taken which are integral to running a business and he can't run it, and he needs those back. Well, there are certain things you can do. They can be imaged, you can get those returned in any event. It depends. The return of the material, you will often hear that. That's what I want back, I want back. Depending on how nervous your client is about the investigation which is now in train. If he's extremely anxious about the return of the material, it may give you a pointer as to what he thinks may be found upon it. If it's, well, I can't run my business, I really need these computers back and then they can make hay with them, I'm not bothered. Again, that'll indicate to you perhaps what police may or may not find on it. But that's one motivation, and certainly one you'll hear commonly: can I get my stuff back? The short answer is, in some circumstances, you can. You generally have to show bad faith when you bring your challenge to get a return of the material. I'll come on to Section 59 of the Criminal Justice and Police Act, which is the more common outcome. But the short point is you can get it back, but it's not necessarily in all cases. The cases where you can get it back, and frankly which are more susceptible to these sorts of challenge, are the corporate business type offences. There's an obvious difference between an allegation of fraud involving a company where this sort of equipment's been taken and there is third-party material on it, perhaps legally privileged material, or what's defined under PACE as excluded material, that's medical records and such like, or other confidential material that your client holds that relates to a third party. If you've got that sort of material, and again, they're your sort of business type offences, you'll readily understand or see that they are much more susceptible to a challenge than, say, someone who's being investigated for having indecent images on his computer of children. Well, if that's the allegation, well, the warrant may be faulty for any number of reasons, but you're going to struggle to get that computer back. And I'm sure you can see that, and you're going to struggle to get an image of it back. So the type of investigation is quite important. They'll want to know, well, can I halt the investigation? Well, often dovetails with, can I get the material back? You can halt the investigation. I've done it in a number of cases. It can happen. You will need to halt an investigation, an injunction pretty early that prevents the police from examining the material. If they're allowed to examine it as the case unfolds and goes through the High Court, taking 8 months or so, however long to come to fruition, you get to the end of it and they've examined everything anyway. Well, you're not going to hold the investigation. It doesn't have to be an injunction. Very often, if you've got a good claim, the investigating authority will undertake not to examine your client's material until the proceedings are brought. So, yes, you can halt the investigation, not necessarily with a silver bullet though, because what you find if you've got your injunction or you've got your undertaking, that just pauses it. And delay is your friend, because just for very human reasons, delay tends to take the wind out of any investigation. The investigators retire, they go on long-term sick, they move on to different departments. different areas. They are moved, because nothing's happening with this investigation, by their superiors to a more pressing investigation. And so it's not a silver bullet so much as the investigation losing its head of steam and petering out. The fun bit for the police often is when they use that big metal thing and put the door in and they all rush in and there's lots of shouting and they're turning all the drawers out, and that's lots of fun. That's lots of fun. It's not so much fun when they get back to the station and after they've popped the champagne corks, they're hit with an injunction and they can't do anything for 8 months. Well, then somebody's got to pick up the thread 8 months down the line. And let's face it, no one likes doing that. You've forgotten what it was all about in the first place. And let's face it, it's nowhere near as exciting. So you can halt the investigation sometimes with that silver bullet, but more often by delay. And again, I'll talk about Section 59 in a minute. But very often the outcome from a successful judicial review is that you then have subsequent litigation in the Crown Court, which is a mechanism whereby if you're right, you claim successful, they hold the material unlawfully, they have a second bite of the cherry to try and regularise their unlawful possession. And that itself can take another several months, depending on the size of the investigation, how much material they've then got to go through, etc. Again, it's delay, and that can be your friend. The third reason, or the third motivation from a client's perspective, and you've heard about this already from Paddy, is a vindication of rights. It's very real. People can feel violated and very wronged by police action. This will obviously apply to those of your clients who really are genuinely innocent. Often, and I see it fairly regularly, warrants are obtained on the back of what turns out to be just maliciously provided intelligence. They haven't bothered to check it out at all or corroborate or verify it in any way. It'll just be one of those anonymous phone calls to one of the lines, and they go, "Oh, great, let's go and turn this guy's house over," and he's completely innocent. And when it's uncovered that they've done nothing to, in breach of Code B, to verify any of this information, they think, well, why shouldn't I be vindicated for this? And so that will apply in a number of cases. Perhaps the paradigm example might be, as war stories are being told, Harry Redknapp's case. You'll remember he was investigated and prosecuted several years ago for tax fraud and eventually acquitted. And of course that started, or at least fairly early on, the overt part, was a raid on his house, 6 o'clock in the morning. In fact, Harry was at a game in Germany, but his wife was there in a dressing gown when the police came through the door at 6 o'clock in the morning. They searched his entire house, including the swimming pool. I'm not sure what they thought they were going to find in the swimming pool area, but they probably just wanted to look, let's face it. So they searched his swimming pool area and they took away but one item in the course of that raid, and that was a laptop computer. And when Harry was interviewed, he said, "Look, I don't even know how to turn that computer on." He was right about that, because when they eventually did turn it on and have a look at his computer, it had nothing on it apart from an operating system. So there was no reason that really, in the context of the allegation, to search his house in the first place. They took this one item, which he knew was absolutely worthless to them in any event. But what really upset him was that at 6 o'clock in the morning, journalists and photographers from The Sun were on ladders watching the police go into his house while he wasn't there, of course, and only his wife was. Now, how on earth, on an ex parte application for a search warrant, the whole purpose of it being that no one finds out about it, how do you think The Sun found it? Well, there's only one reason, isn't there? And that's why he brought the claim, to vindicate his rights, and it was, in fact, successful. Subheading, potential of challenge to arrest and detention. Previously, there used to be objections sort of fairly consistently brought. You're in the wrong court, you need to bring a private law claim. That's rather gone now, and it's regularly done. Not least because bringing two separate claims in private law and public law is not really consistent with the overriding objective. And so if you challenge a search warrant by way of judicial review, and if you want a quashing order, that is the only way it can be done. If there's been arrests made as well at the same time, and of course often there are, subsequent detention at the police station, you can challenge that too. And again, that can be very much part, as Nick and Paddy have both said, of vindicating someone's rights when they think they have been wronged. And lastly, damages, really a bit, unless you're in the territory of the Chenguiz brothers, who have the financial clout to really take on the SFO in a meaningful way, and can demonstrate some sort of huge loss as a result of unlawful actions, your damages are going to be relatively limited to trespass. They can be greater, as I say, if there's business loss. If that's the territory you're in, then you're probably going to litigate. That's the second part, litigate for damages, not in the public law environment, but it'll either get transferred to the county court after the event if you're successful, or to a judge of the Queen's Bench Division if you can't agree damages with the other, which you normally can't because they normally don't want to pay anything at all. So unless it's down at the level of trespass, we're talking a few £1,000, if it's substantial, you're going to have to litigate that somewhere else. So that can be the fourth motivation, but it tends to be ancillary. And far more interesting, second subheading, far more interesting is the lawyer's perspective. Why do you want to do this? Well, the first reason, it impresses your client, and it does. Because not many criminal lawyers think to do it. Or if they want to do it, they're not really very sure how to go about it. So if your client comes in distraught, back to the beginning, distraught, like this has happened, what am I going to do? The advice that they'll very often be given is, don't poke the sleeping tiger. Let's cooperate, keep our powder dry. Well, that can be the right advice. Of course it can in a particular context. But this is the point. We don't have to just react. That's the criminal process generally. Yes, we react to what the prosecution brings, but go on the offensive. That's what challenging the process is. And they're not used to it. They're not used to it. And they don't like it because they're uncomfortable with it. It's taking the fight to them at a very early stage when they're just not expecting it. So challenging the process is proactive, and you'll have very many clients who like that. I've got a lawyer who's not just telling me to bide my time here, save it for when I give evidence. We're taking the fight to them in the High Court. And the second reason is that it raises your profile. If you're successful or frankly, even if you're not successful in these cases, there aren't really that many of them that go through the High Court. They're pretty much all reported. So they're pretty much all getting the law reports. They also pretty much all get into the practitioner's guides. So it raises your profile. If you do one of these cases, you're going to be noticed because you're on the case. If you do two, you're a go-to person. You're a leader in your field. And if you do three or more, I'll sit there. One of you can come up here and do this next time. Okay, so seriously, it really is an area where you can make a splash just by doing a few of these cases and being proactive. So, how to challenge? How am I doing with time, Becky?
Plenty of time.
Right. How to challenge? Well, challenging the process, as I've said, by judicial review. You can't get it quashed anywhere else. You can't get a warrant quashed by bringing your own Section 59 application. It's a court of coordinate jurisdiction. You can't get it quashed in private law proceedings. So the only place you can go is the High Court. It's most often, as I say, search warrants. Well, where do you start? Where do you think, well, have I got a challenge here? Well, the obvious place is you look at the face of the warrant. You'll be familiar with those because they're always given, or they at least should be given, to anyone who has suffered a search and seizure operation under warrant. So have a look at it. It'll take a while to get used to what you're looking for, but just start with the obvious. Read it. Sometimes they're so badly worded that they don't make sense. You put yourself in the shoes of the person. It's my house, here's the warrant, they want to search my house for what? Can I actually understand what they're looking for? Is it appropriately worded? If you can't understand it, well then you've probably got to play. The second obvious point to look for is how wide is it? Is it actually limited? You'll often see warrants now which say, there's some sort of catch-all at the end which say, oh, we want to take computers, phones, documents, checkbooks, and anything else relevant to the investigation. Anything else relevant to the investigation? This is an order of court. That is not an appropriately worded warrant which is capable of being policed by the householder, because it's entirely subjective to the person who's executing it. And the person who's executing it is not the person who has to be satisfied of the statutory criteria. That's the judge who's granted it. And in public law terms, no judge could be reasonably satisfied that a phrase like that satisfies the criteria of being specific, and that's section 15 or section 15(6)(b). So they're just two sort of really obvious things to look at on the face of the warrant. The second place to look, and you may be familiar with these, you may not, they're in your packs, are the application forms. These will now accompany all applications for search warrants. Until the Rawlinson and Hunter case, which was 3 or so years ago, there were no pro formas, or if there were pro formas, they were specific to each police force. They're now standardised under the criminal procedure rules. Have a look at it, either flip to it now or in your own time. They very much mirror the statutory criteria. You'd be amazed, they still get it completely wrong, even though they have fact prompts which take them through section 8, as it usually is, section 8 of PACE or whatever power is being invoked to get these warrants. They'll still get it wrong. But you'll be less familiar with them. You are entitled to them under the common law, unless there's something sensitive, and there may be, at which point the police have to make a PI application to keep that from you. But as a general rule, your client is entitled to know and take advice upon the basis on which process is issued, which obviously engages his fundamental rights over property and over privacy. And you will often find that where they go wrong is in their duty of full and frank disclosure, their duty of candour to the court. It exists in all ex parte applications. They have got to tell the court anything which might militate against the grant of process. Do they do that? Well, their natural inclination is, of course, not to. So you will very often find that information which would very much militate against the granting of a warrant is left out, or it's been fluffed up a bit, to use the vernacular. In other words, they have overblown what the allegation may be or the basis upon which it is sought. So that's probably something you'll need instructions on, and it won't be apparent to you until you get the application form and know what the court has been told. You can challenge other process, so section 18, section 32 most usually. It tends to be more difficult because they're here and now powers, as you'll readily appreciate. There's very little written down. You might get an inspector's authority or something like that. But you can do it. What I have found recently is that the police are starting to use section 30. They know warrants get challenged and that they feel unable to get them right, and so they don't get them at all. So they'll turn up now and they'll say, "Oh, we're going to use section 17 to go in. We'll have a little look for the suspect. We'll have a little look. Oh, there they are. We'll do a bit of arresting. Now we can do a bit of searching under 32 and seize under section 19." When you go, well, hang on, this is a planned operation. Yeah, go and get a warrant. That's the scheme of PACE. That's what you're supposed to do. That's the protection of the public. So you see those powers being used more and more when perhaps they shouldn't be. You can challenge them under JR, and you can challenge seizures under section 19. Section 59, the lesser known provision, although some of you probably will have come across it now because it's getting more and more commonly used. It's often where you end up after successful litigation nowadays. Successful as a claimant, that is. The result of successful JR proceedings is the materials unlawfully held, and what the courts have held, I don't agree with it, but that really is neither here nor there, that what this provision, at least in part, was designed for was to give the authority a second chance, a second bite of the cherry to go back to the Crown Court in front of a judge who will know virtually nothing about civil process and how to litigate rights over property, and they will bring an application to try and remedy their possession by effectively satisfying the judge that the statutory criteria for the issue of a warrant would issue for the material that they've already got. So that's where you'll often end up. And again, emphasise, going through that process itself can be your friend because it can cause delay. So don't think, well, what's the point in challenging it by way of JR if all I'm going to do is end up in the Crown Court? Well, because you'll be litigating that, the start of the investigation, 18 months, 2 years since the kitchen door of your client's premises was put in. And that can be very useful. But if you are of the view that the warrant, for whatever reason, is not susceptible to challenge, or it's not worth bringing full-blown proceedings for judicial review, but there's been excessive seizure, so the warrant authorises a search and seizure of X, Y, and Z, and they've also taken A, B, and C, you can bring your own claim under Section 59 for the return of A, B, and C because there was no authority to take it in the first place. So the Section 59 is a provision that can be used by both sides, and do be aware of it. It's worth having a look at it. Okay, so I'm pretty much out of time, but I've said what I wanted to say about challenging the process. That's the front end, and you've got again some helpful slides about Article 8 and malicious procurement of search warrants, which again fall into the sort of the afters, as it were, of criminal process.
Thank you very much. Thank you, Rupert, and thank you to Paddy and Nick. Particularly thank you to all three of you for keeping to time, because we do now have the opportunity for some questions. If you do have a question, just raise your hand and say who you are so we know. So.
I'm Kevin Lowry-Mullins from TV Edwards. My question is directed to Rupert. Basically, you've mentioned about JR and the search warrants. Where does the funding come from?
Pretty much exclusively privately funded. Or you could do it under a CFA. I mean, I haven't done one, certainly under legal aid. I think you'd struggle to get legal aid for it.
Thank you.
That's good and bad news, isn't it? Question at the back, yeah.
Hi, I'm Catherine Evans. I'm a research student at Queen Mary. You talked about vindicating rights and getting satisfaction for the client. Do you think there's a risk when you want to have accountability and potentially action against the police if you settle out of court without admission of a liability? Is there a risk they'll use that to avoid accountability?
Is that to me?
Yes.
I don't think they won't avoid accountability. You won't get the public declaration, if you like, although there would be nothing to stop your client necessarily in publicising it himself. But I mean, if they concede your claim in totality, as it were, you've got nothing to litigate. Or if you have, you lay yourself open to being criticised about bringing an academic claim, which is not really going to take you any further than the concessions that have been made. So if they do fall on their sword, you perhaps lose that public declaration of having a case reported, but nothing to stop your client doing it. I don't think it loses accountability at all.
I mean, just to add to that, most clients are pretty pleased when they get a cheque from the Met, I've always felt that actions speak louder than words, and if they've written you a very large cheque, most people will see that, even if it's without admission of liability, as a effectively tacit admission. And even then, these police actions do fulfil a real function in terms of policing the police. If you have a whole succession of civil actions against a particular police force, sooner or later they're going to start sorting out the problems in that police force that are giving rise to these civil actions. The money speaks in that
It creates
sense.
holes in their budget.
In my experience, the cheque is rapidly turned into a very large bundle of £50 notes, and the client's Facebook page has immediately changed to a picture of them horizontal on a bed of £50 notes with or without clothes. So it's not kept secret very often. But can I say, defendants do try sometimes to insist on a confidentiality clause, and well, it's just a part of negotiation. In Orgreave, the group action for the miners, where we got £450,000 collectively for the miners, they did try that on. And, well, there's no legal right or wrong about that. It's a part of the settlement bit. We resisted it successfully, and of course everyone knows what happened.
But and that's unlikely to happen in public law proceedings, for obvious reasons.
Yes.
Perhaps we should just go back to the question of funding. Rupert's dealt with funding in relation to JR for search warrants. But Nick, do you want to deal briefly with funding for false imprisonment and malicious prosecution?
Essentially three possibilities. Legal aid if your client qualifies on the means basis, and obviously the merits basis as well. Secondly, CFA, but if you're doing all the work on a CFA, you will be pretty keen to be confident about the merits of your client's case. And then thirdly, obviously private funding, but again, your client in particular will be interested that you're confident in the merits of his or her case. So those are the three essential options. There are wrinkles, but it's probably too complicated to go into more detail now.
Any other questions? Yes.
Why would you think that you couldn't do a judicial review of a public law contract?
I suppose it's possible. I mean, I haven't done one. I think it's probably the subject matter of it, because you're engaging with a court order and you're interfering with the criminal investigation. It might be difficult. It's not something that I have any experience of.
Joel?
Just a contribution on the last subject and a question. On confidentiality, and we were settling one against the CPS last year, and they said we want a confidentiality agreement. We said, well, it'll cost you X tens of thousands more. And the client said, yeah, okay. Yeah, only tens of thousands, but we signed the agreement, so I can't. The question is this: when we were doing this stuff, and I speak particularly to Paddy because he led me in one of the cases you spoke about, but we always used to, because we didn't like judges back in the day, we always used to want juries in civil actions. But in fact, if I was now starting a civil action with a client with questions in his or her background, I think half the time I prefer a judge alone these days. I wonder what the panel think of that.
The answer to that is very often yes, and it's a function of the change of tactics by police lawyers, who are now very much adept at a sort of populist ranting Trump line about, this is your taxpayers' money, are you going to pay it to this scumbag? All right, there may have been some slight infringement of his rights, but come on, look at his lifestyle, etc. He's the other, and so it's judges who can separate out the rubbish from the real merits of the case, and frankly also one doesn't want to be complacent about our judiciary, but even in crime, the acquittal rates of judges in Northern Ireland on criminal trials sitting as judges alone is quite high, and they do a quite extraordinary job. So we're lucky to have the judiciary we have. Let's hope we keep it that way. Yeah.
Of course, I was going to say it's right that both the claimant and the defendant police force have the option to choose trial by jury. If the claimant decides not to have one, but the defendant decides to have one, then you're stuck with the jury.
Yeah, just one gloss on what Paddy said about choosing the judiciary. Don't at Central London County.
Oh no. You've got to know who your judges are.
You need to know who your judges are, and freedom is a nightmare.
Yeah.
Anybody else? Any other questions? Yes.
I'm just curious about your thoughts on the unfortunate demise of your client. I think that was Fred.
Mr. Trinidad.
Do you think that it was of his own doing? Given the scenarios and all that you've said, do you think it's one of those?
He was probably on a high in more senses than one, I suspect. But what were the contributory factors towards his demise? I don't know. It's an imponderable, really, isn't it? He died a happy man.
Anybody else? Yes, please.
Hi, I'm Kerry Hudson from Bulletin Board Solicitors. Do you think there's going to be any scope for challenging the police's new tactic in just basically releasing everybody under investigation?
Do you mean not on bail? As a result of the new
a couple of weeks
provisions?
ago, the new action was enforced, so every single case is just under investigation now. So is there any way?
Well, I've already been asked that by someone actually, and certainly my view of the reason that they were brought in was not to limit the length of time that investigations could take, but very obviously limit the time that people could be kept on bail, which interferes with their Article 5 rights and carries a power of arrest if they breach their bail conditions. So you never say never, but given that that seems to be the policy reason and the purpose in bringing in the provisions, and not, which I think what you're driving at, limiting the time that something's investigated, I think it would be difficult.
You'd have to think what civil right is being infringed, or what civil wrong is being committed by somebody merely being investigated by the state without any restriction on their liberty. And it's rather difficult to think of what a course of action would be and what the basis for illegality is. I suppose there are defamatory implications on publicising the fact that somebody is under investigation.
Well, the example I had was somebody who was being investigated for a sex offence, and he was asking me whether or not he could still apply for jobs in education. Because obviously if he was on bail, then he'd probably have to declare that, but the fact is, under investigation, he could be under investigation for 5 years for all we know.
Exactly.
But, I mean, I've had a case with not quite that problem, but with visa problems created by that. But how do you know if you're? I mean, I might be under investigation. I don't know. Any of us might be.
Should be.
Right, I'm going to draw a line under the questions. Please stay for a drink. Follow-up questions to the speakers, obviously, whilst you're having a drink and a snack. For future reference, if you do have any follow-up questions which occur to you once you've left, please feel free to pick up the phone and ask to speak to a member of the Actions Against the Police team. We will be happy to field those queries, whether or not you're instructing us. So take advantage of that if there's anything else that you want to ask. And please stay. Thank you very much.